To the land transactions workshop. We shall be looking basically on how we can discuss this land transactions workshop. And please, if you listen at the end of the video, I will give you tips on how to pass a land oral exam. So please bear with us, and don't forget to like, subscribe, share, and comment, so as you don't miss tips when we are going to an oral exam. We shall be giving you tips on how to pass land oral exams. So this module deals with different principles relating to fraud in land transactions. So basically, when we talk about fraud, different cases have defined what fraud is. From the case of Frederick Zimbabwe versus Orient Bank, where the court stated that fraud is when you part away with a thing which does not belong to you. So we also see the case of David Sejak and Arima, where also the court comes in and finds fraud, that where we are supposed to do an act and you don't do it, then fraud can also be imputed on you. So fraud can take a lot of forms. You have to be alive to that fact. We shall also look at consequential orders, and consequential orders apply where you have, for example, a judgment. Then you can apply to the High Court, and they can order the registrar to transfer the titles into your own name. So we have gotten a judgment, for example, in the magistrates courts. You can proceed under consequential orders to apply that now they force the registrar to vest that title into your own name. That's what we call consequential orders. Then we shall look at the special powers of the registrar of titles under the RTA. Of course, it has powers to rectify errors in the title. In case a title was issued in error, then the registrar has powers to cancel that or correct those errors. But we shall also see other powers like issue of special certificates, and also in instances where the original has been lost. So we shall also look at challenging the decision of the registrar of titles, condominium properties, and physical planning. So basically, condominium properties is where you find that someone owns skyscrapers, but then you are selling different levels. Those are what we call condominium. So each individual can come and buy a level, for example, and then proceed to own it. So we shall also look at Physical Planning Act, which we shall also look at in the previous workshops under the Physical Planning Act. So by the end of this module, students will be able to explain the different principles relating to fraud in land transactions, consequential orders, the special powers of the registrar of titles, challenging the decision of a registrar of titles, condominium properties, and physical planning. So demonstrate the tenets of fraud in land transactions, grounds to obtain a consequential order, special powers of the registrar of titles, and where necessary to cause or enforce performance of duties of the registrar of titles. So basically, we shall see how do you enforce the performance of the duties of the registrar, and also how do you obtain a consequential order. So I said for you to obtain a consequential order, you must have a valid judgment. So you extract an order. For example, if you recovered your land in the Chief Magistrate's Court and they say that you are the owner of that land, then that means you can proceed and apply to the High Court, and then they will order the registrar to do what we call a consequential order, where they transfer that land into your own name. That's what we call a consequential order. We have looked at fraud, and we have said fraud can take different forms, according from the case of course, Orient of Frederick Zimbabwe versus Orient Bank, and also Rebecca Musoke, and in the case of David Sejaka Narima. So draft various documents needed to claim for fraud in land transactions. So when you are claiming for fraud, of course, we go by a plaint. Once there is a fraud, we shall always go by a plaint. Then to obtain a consequential order, you must have you extract an order, and then you proceed by notice of motion. Then special powers of the registrar of titles, and challenging the decision of the registrar of titles, condominium properties, and physical planning. So you should read the following legislations and authorities before the workshop. The list is exhaustive or not restrictive. It merely serves as a guide. So here in recovery of land, we have David Sejak and Narima versus Rebecca Musoke, which is a locus classicus on fraud. Once you are supposed to do an act and you don't do it, then court can impute fraud on you. In this very case, a lawyer went to buy land for the client, and he found an old woman on the land, but he did not inquired how the old woman came to the land. So fraud was imputed to the client. So we also have Frederick Zagwe versus Orient Bank, which basically deals with fraud, but in light of the powers of attorney, because I think the person had been given powers of attorney to mortgage, and then he proceeded to sell. So that was the issue, whether there was fraud, and the case discussed what is fraud and all other things. We shall also look at illegality and error. We have the case of Patel versus Commissioner Land Registration and others, where in case a title has been issued in error, then you can move the registrar to cancel or clear that illegality in the title, but he has to issue a notice, and then he has powers to cancel. Then remedies, consequential orders, jurisdiction, conditions, procedure, and documents. Ruanga versus Register of Titles also discusses fraud, whereby you have gotten judgment from a magistrate court which has declared that you are the rightful owner of the land. Then you can proceed under consequential order to apply to the High Court, which will order the registrar to vest that land into your names. Then bona fide purchase of value without notice. It has been discussed, of course, in several cases, to wit Daniel Sempa, Babari versus Kiza, and 4 others, where the court stated that for you to become a bona fide purchase of value without notice, one, you must have paid a consideration, you must have a certificate of title, and you must not had any connection to the fraud. So basically, once you can prove that you have a certificate of title, you were not part to the fraud, and there is no way you could have found it out, and then you paid variable consideration, then the court basically can allow you to proceed under bona fide purchaser for value without notice, which is going to be a defense. Then lawyer fees agreements, which we looked at, of course, in the professional code of conduct, and the case of Bienchach and company and others versus Fangmin, where we are saying that you cannot sign a champati agreement. I think we discussed that in professional conduct. Then cases on fraud have looked at that meaning of fraud. Fraud has been discussed in several cases, that it takes different forms to include you when you're supposed to do an act and you don't do it, fraud can be imputed on you. But also when you do an act with the intention of parting with something that does not belong to you, it's also going to be fraud. Then meaning pleading. So pleading, fraud must be strictly pleaded. You have to plead fraud, and you must make sure that you have connected it to the defendant. So fraud, all the particulars of fraud must be pleaded how they happened, and it must be connected to the defendant. So burden and standard of proof, of course, section 101 of the Evidence Act, he who alleges must prove, and the standard of proof in civil litigation is on balance of probabilities. So consequences of trespass and recovery of land. And then we shall look at illegality and error, which have looked at remedies of consequential orders, jurisdiction, conditions, procedure, and documents, as well as bona fide purchase for value without notice, which we discussed above. So workshop 1, the workshop deals with the different principles relating to fraud in land transaction and the process of obtaining consequential orders in land matters. So by the end of this workshop, you should be able to explain the different principles relating to fraud in land transactions, demonstrate the tenets of fraud in land transactions, grounds to obtain a consequential order, draft various documents needed in a claim for fraud in transaction to obtain a consequential order, and organize and deal with issues relating to claims for fraud in land transactions and the process of obtaining consequential orders. So assume that you are a legal assistant at PNA Advocates located at Post 47 Kampala Road. Mr. Smith Mugaga is before you. He informs you that he was the lawful registered proprietor. The different certificates of titles are described below and include land comprised in 3124-12. This plot is unoccupied and only has a wall fence along the boundary of the plot. Land comprised in Busuro at Busuku, where Mr. Smith carries out his poultry farm. land comprising Chandodo at Kawempe, where he resides with his family, and land comprising Chandodo, which is underdeveloped and completely unoccupied. That sometime in March 2023, Mr. Smith wanted to open the boundaries of all his titled properties. So he instructed his longtime friend, Mr. Mugezi Clever, a renowned surveyor, to carry out that work. Because Mr. Smith trusted Mr. Mugezi Clever, he handed over all the dispute certificates of titles to him on the 25th March of 2023. Mr. Mugezi did carry out the instructions issued to him in the presence of Miss Smith and all his immediate neighbors. Mr. Mugezi returned all the duplicate certificate of titles to Mr. Smith on the 2nd of May 2023. Last week, he received an offer from Mr. Patel Singh to acquire his land. Mr. Smith welcomed the offer with excitement, shared with Mr. Patel Singh a clear copy of the duplicate certificate of title, his land at Buziga. Mr. Patel, being confident with the online search application, immediately verified the particulars of the land. Mr. Patel found out the land at Buziga was transferred to administrator of the late Smith Mpuga, VID administrative cause number 0124 of 2024. Mr. Smith tried to contact his friend, but his phones were off. Mr. Smith then carried out searches on the certificate of titles and was shocked with the investigations below. It was revealed to him that the land at Buziga was transferred from his name, the administrator of the late Smith Mpuga, Mr. Mugezi. The land at Busiro at Usuko was transferred from Mr. Smith to Mr. Praise Murungi, the immediate neighbor. Channel Brook City at Kawempe was transferred from Mr. Smith Mugaga to Mr. Praise Murungi, having also purchased it. Miss Praise Murungi then gifted it to Junior Murungi, her son, who was just completed university, the current registered proprietor. So basically here we have Channel Brook at Kawempe was transferred from Mr. Smith Mugaga to Miss Praise Murungi, having also purchased it. So the fact that this one purchased, then he can qualify to have what? To be a bona fide purchase of value without notice, as long as you have a certificate of title and you paid variable consideration and you wouldn't in any way have found out that there was fraud. So the land comprised in Channel Brook at Kawempe was transferred from Mr. Smith Mpuga to Mr. Muzito Sam upon a successful purchase. Mr. Muzito has transferred it to Rio Investments Limited, a company that belongs to Mr. Muzito that deals in real estate business, which later transferred it to Silk Textiles Limited. So basically, this Silk Textile Limited can also confirm to be a bona fide purchase of value without notice. But for these ones, for the first transaction, that the defense might fail because you should have made proper due diligence and saw whether the person who was selling was the one on the title. So the bona fide purchase of value without notice in this of Smith of Praise Murungi could fail, and also now Murungi can't succeed because he didn't pay any price. It was just a gift. So I think the one who's going to succeed under the defense of bona fide purchase of value without notice is most likely going to be Silk Textiles Limited. So advise Mr. Smith Mugaga on the steps you would take to establish with certainty the circumstances under which respective titles were affected by the impugned dealings. So basically here you would carry out due diligences in the ministry and you see basically how were these transactions effected, who signed the transfer forms, all that kind of thing. Then B, the legal position of the persons currently registered as proprietors of the respective pieces of land. So basically here we have one of the person who has a gift, and we said because now there was no transfer of title, because the person who transferred to the gift is going to be imputed with fraud because he didn't do proper due diligence. So that means he won't have a valid gift because there was nothing to be transferred. You can't transfer what you don't have. That principle. Then on this last paragraph, this Silk Textiles Limited are mostly likely going to be bona fide purchase of value without notice, because you see, for them, they bought from the company, and this company also was registered. So the defense of bona fide purchase of value without notice, I said you must have paid a purchase price, you have a certificate of title, and also you couldn't have in any way found out the fraud. And we can see these ones bought from another company, so they couldn't have been able to do that. So all steps you would take to recover his land. Yeah, so basically we would have to lodge a caveat on these lands first, and then after that we go and institute a plaint on the land. Then see what other remedy would be available to him if Mr. Smith is not able to recover all or some of his property. So we have you can sue for damages, but also for compensation from the registrar under the act. So those are some other remedies we shall be looking at. So what other remedy would you, so for what steps would be necessary to obtain the said remedy in 3 above? So here you have to, if you talked about compensation from the registrar, you have to do what? You have to take necessary steps to write to the registrar and then get this compensation. Then 5, assume that Mr. Smith filed a suit in Chief Magistrate's Court of Wakiso in respect of the land at Busiro, at Busuka, having valued it at property of 47 million. He subsequently obtained judgment in his favor that read in part as follows. The plaintiff is the lawful owner of the land, permanent injunction. So basically here, what you do is you have to extract the order, and then you proceed to apply what we call a consequential order in the High Court, which basically orders the registrar to transfer those documents, transfer the title into your names. And the procedure, the documents would be the notice of motion supported by an affidavit. So basically that's how we go about workshop 1. But in case you want notice, you don't have a lot of time to make your own notes, and you want a thorough discussion, an in-depth discussion from all members, from students from all the 4 campuses, you can reach out to me in the number in the bio, and then we can add you in our WhatsApp group where we do mentorship, and we give notes and also do discussions on Saturday and Sunday. So in case you want something like that, then you can text me on that number, and members pay a monthly subscription fee, an affordable monthly subscription fee, and then you can be part of that team. But also if you can't afford, we understand. You can keep on getting the highlights from this channel, as well as going and dealing with the details with your firm. We can understand that. So workshop number 2, this workshop deals with the special powers of the Register of Titles, arranging the decision of the Register of Titles, condominium properties, and physical planning. So by the end of the workshop, students will be able to 1. Explain the special powers of the Register of Titles, arranging the decision of the Register of Titles, condominium properties, and physical planning. You must read the special powers of the Register of Titles, and where necessary to cause or enforce performance of the duties of the Register of Titles. Process of converting different land tenures to condominium property. Entries on condominium certificate of titles and management of condominium property. Draft various documents needed to enforce the performance of the Register of Titles and to acquire condominium property. And 4. Recognize and deal with issues relating to special powers of the Registrar of Titles and challenge the decision of the Register of Titles. And condominium properties and physical planning. So part A, assume that that Mr. Smith recovered this land in respect of the property, measuring hectares at Buziga via the court order, and he was subsequently reinstated as the registered property proprietor. Mr. Patel Singh is now ready to enter into the transaction with him, although he is now interested in purchasing only 100 acres. On the day for the transaction, as Mr. Smith Mugaga was getting off the motorcycle, he accidentally slipped and fell, and in the process, the certificate of title fell in the trench full of that water due to the area heavy downpour. Mr. Smith then realized that the certificate of title was holding totally wet and all illegible, as some part points have been rubbed off the title. Advised Mr. Smith on how he can obtain replacement of the title certificate draft the documents required to sustain the replacement, and fees required to obtain the remedy. So basically here we have what we call a certificate of title, which was a duplicate certificate of title, which was obliterated or got destroyed. So you have to understand an original certificate of title, because the original certificate of title is always kept with the registrar. Then the duplicate is the one you always be having. Then also have a special certificate which can be applied to in case you, for court, for example, if in case court orders that they give you a certificate of title. So how can he obtain replacement of certificate of title? When you look at section 71, if any original certificate of title, section 69, if the duplicate certificate of title is lost or destroyed or becomes so obliterated, you can apply to the registrar followed by statutory declaration. This application is by way of letter and then supported by statutory declaration. Fees required to obtain the remedy, you will have to see in the RTA provided for those fees. Then part B, assume that while you were in the process of obtaining the replacement in parts 2 above, you discover the original copy cannot be traced. Advise Mr. Smith on the steps you would have to take in circumstances and draft the documents required in 1 above. So basically, the original certificate of title is always kept by what? By the registrar. And when you read section 71, if any original certificate of title is lost or destroyed, also obliterated as to become eligible, the registrar may cause a copy of it to be prepared and to be endorsed with all such entries as were upon the original, so far as they can be ascertained from the records of office and other available information, and shall make and sign a memorandum upon the copy stating that it's a substitute to be used in place of the original, and what has become of the original so far as known or supposed. And from the date of the copy being so signed, it may be bound up in the registrar's book and used in place of the original for the purpose of the dealings. So basically here what we have is the section that provides for that procedure, that it's the powers of the registrar to do that. So that means here the registrar wouldn't be doing his or her work. So documents, I think what we are going to draft could be a notice of motion supported by an affidavit, but I haven't satisfied that. But from the reading of the section, it does not give us any way of procedure. And what I can see is the registrar is not doing his job. So I am not certain at this stage whether it's an application of the registrar by letter, or we can proceed by those ways where we don't have any modes of application. That's something you should confirm with your firm. But just read section 71, it will guide you where the original certificate of title is lost. Then part C, assume that it is now over a year and the remedy in part A has never been obtained, despite the fact that Mr. Smith paid all the fees and forwarded all the pertinent documents to the Register of Titles. The front office personnel at the Land Registry have informed you that the documents were rejected by the Registrar of the Titles, and no explanation whatever has been given for the rejection. Mr. Smith also tells you that he has not received any formal communication in respect of the registration of the rejection. Advise Mr. Smith on the steps you would have to take to cause the Register of Titles, provide the remedy to Mr. Smith in part A, and draft all the documents that would be used in the process in 1 above. So basically here you would have to appeal because now they are not doing anything, so you would have to appeal to the court. So when you go to the court, they would do what? They would force the registrar to do his powers. So draft all the documents. I believe here the documents would be the notice of motion supported by an affidavit. So part D, assume that after completing the transaction between Mr. Smith and Mr. Patel in part A, Mr. Smith is now ready, anxious to develop the remaining land with 3 blocks of apartments, intended to sell the different apartments people advise Mr. Smith on. 1, the steps you would have to take to cause each apartment to be legally owned by the different people interested. So basically here when you look into the Condominiums Act, they give you the procedure under which you can turn land into condominium property. So basically here the land has to be owned under leasehold, and then you apply so as you can do what? You can get that land, you can be allowed to develop condominiums on the same part. So basically that's what you have to do. Follow the processes in the Condominiums Act. Draft and answer documents between the developer and the property owners who purchase units. So basically this is going to be a sales agreement. As long as they purchase, then we draft a sales agreement. The relationship between the different owners in regard to the property as a whole. So basically once you have paid, you have a lot of rights that accrue from that property. For example, you can use it, of course. For example, like we have areas which are common, like for example, if they have a swimming pool, those ones everyone is entitled to them. Like corridors, columns, those ones they can be used by both the condominium owners, but the individual condominiums would have to be owned by different owners. But what is important for you to understand is that some of the property is going to be owned by both of you. For example, the compound, and you have to erect what we call a corporation for managing of the compound, and basically how are you going to contribute to keep it clean, and what other things which are used by all of you. And also before you set up a condominium, you have to also look at the provisions of the Physical Planning Act, and you follow the law on physical planning. Have your plan being approved by the district planning committee, like the way we used to discuss on those things of the physical planning committee, and also approving your plan. Then, supposing that some of the tenants renting the apartment from Mr. Smith have become interested in legally owning the apartments, advise Mr. Smith on the pertinent changes, if any they are necessary to be made. So if now we had tenants, that means tenants they are owning under what we call a tenancy agreement. So now if they want to buy, if they want to buy the condominium, that means we have to create different titles. We have to give them also their own titles. So we shall have a mother title as well as individual titles. So we have to look at that. Basically, how are we going to give them their individual titles? So you have what we call a mother title, and then individual owner's title. So that's what is created from all that. So I think that's basically the highlight I can give at this time. And in case you are interested in our mentorship groups, please inbox the number on this YouTube profile, or it's 075 67 284. You can WhatsApp me on that number, then I will give you more details. Basically, we have discussions over the weekend. They are online. We have students from all the 4 campuses, and then we also give notes immediately after the discussion. So in case you want something like that, then you can inbox me, and then you'll be part of that team. So please like, subscribe, share, and comment, and do not miss to put on that notification, because here we analyze all the workshops, both from the first intake and the second intake. So I promised you to give the advice of passing the oral exam. The way you can pass oral exam is preparation. You have to prepare and also be confident, because they will be asking you the same questions you are meeting in your workshop. So don't expect different questions. Once you have understood all the workshops, then of course you're going to pass the oral exams. So please have a blessed day, and may God bless you.